Under Article 255, the law punishes infanticide. Infanticide is the killing of a child less than 3 days old or less than 72 hours. In case of infanticide, what you consider is the age of the victim. It is the age of the victim that controls the crime that has been committed. Therefore, regardless of who may be the offender, whether the offender is the parent, the mother, the grandmother of the said child, or the offender is a total stranger to the said child, for as long as the said child is an infant less than 3 days old or less than 72 hours, the crime committed is infanticide. If the child is already 3 days old, it is no longer infanticide. It now depends on who is the offender. If the offender is the mother, the parent, it will be parricide. If the offender is a total stranger, it will be the crime of murder qualified by treachery. So the woman gave birth. After giving birth, she decided she wanted to get rid of the child in order to conceal her dishonor. She doesn't have the nerve to face her family with this child, she being unwed. However, he could not do it. He asked the help of a good friend from school, and both the said mother and the said good friend from school killed the said child. The child was a day old. What primary crimes had been committed by both the friend and the mother? They shall be charged with only one crime as conspirators in the crime of infanticide. Only one information shall be filed in court. The mother and the friend being conspirators for the crime of infanticide. Conspiracy would lie regardless of relationship because it is the age of the victim that controls, the victim being less than 3 days old. However, in case of the judge ruling the case, when the judge rules the case, it is necessary for the judge to consider the fact that the mother killed her own baby to conceal her dishonor. Such act of the mother of killing the baby for the purpose of concealing her dishonor would mitigate the criminal liability of the mother. The penalty for infanticide, if the offender is the parent, is akin to parricide, reclusion perpetua to death. And if the killing was done to conceal dishonor, under Article 255, it shall be lowered by 2 degrees. Therefore, it shall only be prisión mayor. Therefore, concealment of dishonor is an extenuating circumstance that will lower the imposable penalty on the part of the mother by 2 degrees. This extenuating circumstance of concealment of dishonor, however, would not lie in favor of the friend who cooperated in the commission of the said crime of infanticide. That concealment of dishonor is personal to the mother and cannot apply to the said friend. Therefore, the friend shall be convicted as charged and imposed with a penalty as prescribed by law. Reclusion perpetua. What if this time, same facts, but this time, before X, the unwed woman, could decide whether to get rid of her baby or not, it is already 3 days from giving birth. He could not decide, it took her 3 days to decide. And on the 3rd day, final decision, she has to get rid of the baby to conceal her dishonor. Ask the help of a friend, both of them killed the said baby. What are the crimes committed by both the said woman and the friend? This time, 2 informations will be filed in court. The woman would be charged and be held liable of parricide because the baby is already 3 days old. And the friend, even though there is conspiracy, would be charged not of parricide because of the absence of relationship, but rather of the crime of murder qualified by treachery. Conspiracy now would not lie the moment the child is already 3 days old and above. And in the ruling of the case, since the crime committed by the mother is no parricide, concealment of dishonor is not an extenuating circumstance in the crime of parricide. Therefore, it will not lower the imposable penalty on the part of the mother. Then we have abortion. Under Article 256, the law punishes intentional abortion. Under Article 257, the law punishes unintentional abortion. Under Article 258, we have the so-called abortion practiced by the woman herself or her parents. And under Article 259, we have abortion practiced by physician or surgeon. There are actually only two kinds of abortion. We have the so-called intentional abortion, and the other one is unintentional abortion. Intentional abortion may be committed in any of the following manner. First, by exerting physical violence upon the person of a pregnant woman in order to kill the fetus or the baby inside her womb. Or, number two, by acting without violence, without the consent of the woman. That is, by administering abortive drugs or beverage on the said pregnant woman without her consent. Or, by acting without violence with the consent of the said pregnant woman. That is, by administering abortive drugs or beverage on the said pregnant woman, this time with her consent. These are the three ways of committing intentional abortion. So in intentional abortion, the intent of the offender is against the fetus. The intent of the offender is against the baby inside the womb of the said pregnant woman. His intention, he has to kill the said fetus, to expel the fetus from the womb of the said woman. Insofar as unintentional abortion is concerned, it can be committed only in one manner, and that is by exerting physical violence upon the person of the woman. In case of unintentional abortion, the offender has no intent against the fetus or the baby inside the womb of the woman. The intention of the offender is against the woman, and he may or may not know that the woman is pregnant. But by reason of the physical force, physical violence he employed on the said woman, abortion was caused unintentionally. Hence, the crime committed is unintentional abortion. The woman became pregnant. The boyfriend refused to marry her. The woman was so afraid that the family would know about her pregnancy. In particular, she is so afraid that the father would know of her pregnancy. The father was so strict, and so she was very afraid of the father. She does not know where to go, and so she went to a doctor whom she heard practices abortion. And there the doctor performed abortion on the part of the said woman. What prior crimes had been committed by the said doctor and by the said woman? The doctor would be liable of intentional abortion under Article 259, whereas the woman would be liable of intentional abortion under Article 258. What if, in the same problem, when the woman has nowhere to go, the said woman went to her mother. The mother was also strict, but she knew her mother loved her so much and would be able to accept what happened to her. So the first time she told the mother became very mad. Thereafter, however, out of love, she accepted it. But she suggested to her daughter that this baby must go. The fetus in her womb must go, and there must be an abortion. And so, at first, the said woman didn't agree, but later on, the woman agreed. And so the mother bought an administrative beverage, the best in the market, and administered the same to the said woman with the consent of the woman. After taking the same, indeed, the fetus died. The fetus was out of the womb of the said woman and dead. What former crimes had been committed by the said mother and by the said woman? They are both liable for intentional abortion under Article 258. The fact that the said woman killed the said baby out in order to conceal her dishonor, the said fetus in order to conceal her dishonor, concealment of dishonor is also a mitigating circumstance in the crime of intentional abortion. So it will also lower the criminal liability, the imposable penalty on the part of the said woman. However, this time it is not by degree, but only by your years. So it is only akin to an ordinary mitigating circumstance, not a privilege mitigating circumstance. What if in the same problem, despite the fact that the said mother had administered the abortive beverage on the woman, and the woman had taken the same, after the pregnant woman had taken the same, the said fetus inside her womb did not die. It was not expelled out of the womb. Are they liable of any crime to bring about intentional abortion? The fetus inside the womb must die. So here, the fetus did not die. Are they liable of any crime? They're liable of frustrated intentional abortion. It is a frustrated intentional abortion because both the said woman and the said mother had performed all the acts of execution that will bring about abortion when the said woman had taken that abortive beverage. Nothing more is left to be done. However, the fetus did not die. Therefore, the said fetus did not die by reason of a cause independent of the will of the said woman and the said mother of the woman. So we have here frustrated intentional abortion. What if the neighbor had this argument with another neighbor, a female neighbor, over a piece of land? The said female neighbor put up a fence, and a portion of the property of the male neighbor was taken. And so there was a confrontation between the both of them. In the course of the said confrontation, the said male neighbor got so mad that he pushed and kicked the said woman neighbor. The woman neighbor, because of the force employed on her, landed on the ground, and immediately she started to bleed. Unknown to the man, the said woman was 3 months pregnant. The woman was immediately brought to the hospital. The doctor said she has to stay in the hospital. She needed medical intervention for a period of 35 days. Unfortunately, the baby inside her womb died. What former crimes had been committed by the said man? The man would be liable insofar as the woman is concerned for serious physical injuries. The said woman would be needing medical intervention, medical attendance for a period of more than 30 days. Therefore, it is serious physical injuries. By the employment of physical violence on the said pregnant woman, the fetus died. Abortion was caused unintentionally. Hence, insofar as the fetus is concerned, the crime committed is unintentional abortion. These are two less grave felonies. And these two less grave felonies were the product of a single act of pushing and kicking. Therefore, Article 48 comes in. The crime committed is serious physical injuries with unintentional abortion. But what if in the same problem, despite the violence inflicted by the man on the said woman neighbor, despite the fact that the woman neighbor was thrown on the ground, started to bleed, was brought to the hospital, the doctor said she would be needing medical intervention for a period of 35 days, but the baby inside her womb survived. Despite the bleeding, the baby was still there, alive, and survived. What crime, if any, has been committed by the man? The man would be liable only for serious physical injuries. The crime be committed against the said pregnant woman because she would be needing medical intervention for more than 30 days. Insofar as the fetus is concerned, there is no crime committed. Because in the first place, in case of unintentional abortion, the offender has no intent against the fetus. Therefore, it cannot be considered as frustrated intentional abortion. The man has no intent insofar as the fetus is concerned. So if the fetus survived and did not die, out of the physical violence inflicted on the woman, then there is no crime against the said fetus. Under Article 249, 259, if a pharmacist dispenses abortives without a prescription coming from a physician or doctor, the said pharmacist will be liable under Article 259 for dispensing the said abortives. Under Articles 260 and 261, we have a duel. A duel is a combat, a fight, between two or more persons based on a previous agreement to engage in a fight. For a fight, a combat to be considered as a duel, the following must be present. First, there must be a previous agreement to engage in a fight. Second, there must be 2 or more seconds for each combatant. And third, the weapons to be used and other terms of the fight must be agreed upon by the seconds of the combatant. If these 3 requisites, these 3 elements are present, then the said fight is considered as a duel. And under Article 260, a person who participates in a duel becomes criminally liable if he kills his adversary, if he inflicts physical injury upon his adversary, or by merely accepting and participating in the said duel, he already becomes criminally liable. In Article 261, the mere act of challenging another to a duel, inducing another to accept a duel, or scoffing off, or mocking another publicly for having refused to accept a challenge to a duel, would make the offender criminally liable. Article 262 punishes mutilation. Mutilation may be committed by intentionally mutilating another by depriving him totally or partially of any organ necessary for reproduction, otherwise known as castration. Also, by intentionally mutilating another by depriving him totally or partially of any other part of the body, which is not necessary for reproduction. Mutilation is a crime that requires deliberate intent. The law requires there must be a deliberate intent to cut off, to sever the part of a body of a person. Even if a part of the body of a person was cut off, severed from his body, if there is on the part of the accused no deliberate intent to mutilate or to cut that part of the body, there is no mutilation. It could be attempted homicide, frustrated homicide, attempted murder, frustrated murder, serious physical injuries, but not mutilation, absent deliberate intent to cut off, to sever the part of a body of a person. X and Y were engaged in a fight, and in the course of the fight, X pulled out a long, sharp, shining bolo. It looks very sharp. And he placed it in a hacking position. His intention was to hack the said victim. His intention was to hack the opponent, that is Y. He was about to hack Y, intending to hack his body. However, Y raised his right hand. And because of the sharpness of the bolo, the moment Y parried the blow with the use of his right hand, with the use of his right arm was cut off from his body. What crime is being committed by X? X is liable for attempted homicide. He is not liable for mutilation because there is on the part of X no deliberate intent to mutilate, to cut off the arm. His intention was to kill him, to hack the body, because it was in the course of a fight. However, since Y parried the blow, he parried the blow by his arm was cut because of the said sharp bolo. Therefore, the crime committed is attempted homicide.